You can start now. We can see you. Look at that young man.
Thank you. The last time I did one of these presentations, I had left my old photograph up, and when it was over, I asked if anyone had any questions, and one woman raised her hand and asked. It was an old photo. It was about 12 years old, and my hair was completely black, and now it's not. And she said, "Is that you? Is that a picture of you?" So I did update my photo. First of all, how can we talk about anything involving employment law if we didn't talk about sex, politics, religion, and certainly race? Highly topical topic in the employment arena. There's a wide gamut of increasingly controversial issues being debated amongst everyone: management, employees, clients, customers, vendors. Discussions they used to be at the water cooler. Now they're via Zoom, on the phone, in social media, and we're an incredibly divided society. And it raises some employment law challenges and issues. There's a plethora of issues that people have very, very strong feelings about. Is the election over? Who won? Even to that point. And those issues will not decrease; they'll probably increase. A lot of tensions, and it affects the workplace. Reduced productivity, damage to morale, employees arguing with each other, with clients, etc. It could damage a company's brand. Sometimes employees may end up leaving or be let go for one reason or another, directly or indirectly. Employees who are talking politics or discussing other hot issues with clients and business associates could affect business. And it could also increase the likelihood of employers getting sued by the employees. There are a lot of matters that I've come across where employers are trying to impose their will on their employees to have them think along the same lines as the employer, and it leads to a lot of problems. An example, an employee expresses an opinion the boss doesn't like, or wears a button, apparel that on a topic the boss detests, expresses support for a particular cause the boss opposes, etc. And then while that's happening, the employee gets fired for some reason, maybe low productivity, maybe there's a need for a reduction in force, and very often the employee will assume that the firing was wrongful and must have been related to a discriminatory reason, and then ends up suing for discrimination or retaliation because maybe the topic had to do with a religious issue, a race issue, a national origin issue, etc. So it's a potential hotbed. Private sector employees can restrict employees from engaging in political debate and expression of political beliefs in order to prevent hostility, violence, alienation, etc. You can have a policy in your handbook, but you need to be sure to apply the policies even-handedly and don't have a different impact on what kind of policies you put into place, because that could be discriminatory in and of itself. You can have a no politics at work policy or no political activity policy to prevent employees from congregating. This is pre-COVID, but now on social media or Zoom or otherwise, and discussing these hot button topics, et cetera, or engaging in solicitation of other employees, et cetera, on various issues. And employers can implement training sessions to teach employees how to steer clear of these controversial topics. With everything that's going on recently, this issue is not going to go away anytime soon. We have the challenge of dealing with closing, furloughing, terminating, reopening, closing, reopening again. We may be going up and down for a long time. Everyone is hoping and praying that a vaccine becomes available and gets distributed widely enough and is effective enough to where we can go back to what we remember normalcy to be. But it could be a very long time, and there are a lot of challenges that are going to continue to face us. For your information, I'll tell you this much. No one's done a better job than keeping employers and employees informed than Romeo and Paymaster. Romeo's on top of every issue. I can honestly tell you that when I have questions, I call Romeo because he's so knowledgeable. I'm not just saying that to get invited back next year. I think you all know this to be true. If you don't follow Romeo on LinkedIn, Romeo's on top of every issue. He comes out with a very thought out, excellent piece before anyone else does. Here's a reference to a return to work checklist that employers could consider implementing. The law firm Day Pitney created it. There's a reference to the link. If you Google Day Pitney return to work checklist, you'll find it. I'm going to put this slideshow up on my law firm website probably by tomorrow morning, so you'll be able to access this as well. Lately, the statistics, Employment Law 360, it's not too surprising that employment lawsuit filings have gone down during the COVID pandemic. It's from a pragmatic, logistical point of view, it's hard to have an employee under difficult circumstances get with a lawyer, prepare a suit, investigate, prepare a suit, file, etc. Filings have gone down, but that's a temporary phenomenon. It's going to turn in the other direction pretty soon. As far as employment suits, the volume has been reduced, but it turns out that coronavirus-related claims are increasing. They've accounted for more than 300 cases during the first 3 quarters of 2020. Here you see a breakdown of the different main kinds of employment lawsuits for 18, 19, and 20. And you see which have gone down a little bit or stayed about the same. And you see you see which cases are more predominant than most. Retaliation is very hot, a very hot area. And one reason is an employee can file a claim for sexual harassment, racial discrimination, religious discrimination, et cetera, and be wrong about it and have a baseless claim. But if they get any form of retaliation, which could be almost anything that adversely affects the employee inside employment or even outside employment by the employer, they may have a retaliation claim. So they've become more widespread. Title VII kind of discrimination claims are still prevalent. And one particular area that's always very prevalent are overtime minimum wage claims, which will continue to increase and will never decrease because it's an area that's so difficult to do right, and it's a moving target. If you want to know about the next hot topics in employment law or likely suits, basically insert your company's name right here on this slide, and you could put that bullseye on the backside of the company because there will be more and more suits filed without question as time goes by in the near future. If we're going to start talking about what kind of suits are going to get filed, for what, we first have to talk about who's really an employee, because the EEOC and Department of Labor have had a task force for a couple of years now focusing on companies that characterize the people who work for the company as independent contractors when in fact they're truly employees. There's an old silly joke about, if I told you my dog's tail was a leg and I asked you how many legs my dog had, the answer is not 5. The answer is 4. Just because I told you his tail was a leg didn't make it a leg. The dog still has four legs. Just because you call someone an independent contractor, give him or her a 1099, sign a contract, and pretend, if certain indicia appear, certain elements appear, the Department of Labor is going to conclude that worker is an employee and able to bring overtime kind of claims. The IRS is going to consider that worker an employee and expect taxes to be withheld and paid in and matched, etc. and there's going to be liability of the employer for acts of that worker. So you want to be very careful to do an audit of all the people working for your company to see who is truly an employee and who may very well qualify as an independent contractor. It's an important issue because there's some employment law. First of all, the employment laws apply for employees. They apply to employees. They don't apply to independent contractors. So that's a big issue. That's why I'm mentioning it early in this presentation. The other issue is how many employees you actually have is important. Do you have 15 or more? If you do, then Title VII and the discrimination laws apply. Do you have 50 or more? FMLA will apply, et cetera. So the number of employees you have is important, and whether someone's an employee or not, obviously will open up Pandora's box as far as what kind of claims can be made. There are certain elements and factors that the law looks at as to whether someone is an employee or not. I'm not going to go through the specifics right here. If you access the presentation on my website tomorrow, you'll see it. The 11th Circuit Court of Appeal out of Atlanta that covers Florida and a few other states in the Southeast follows the economic realities test and determines basically if you control what that worker does, if you control the schedule, if you provide the materials that worker uses, and if let's face it, if they're working for you and nobody else, if they're just getting paid a certain amount and they can't really make more by working longer or harder, they're just getting paid, for the work they do for you, and you control, what that worker does and how the worker does it, then you're going to be the employer. And to the extent that those things are not occurring, you could conclude that someone's an independent contractor. But you want to do an audit and make sure you know who's a W-2 and who's a real 1099. We all know that there's been a lot of talk about safety in the workplace with the pandemic in place. OSHA has a general duty clause. You've heard about this before. We've spoken about it. The employer has this obligation to make sure that the workplace is safe. So there are more and more suits that are being filed, some wrongful death suits, people of family members of employees who've died because of COVID or gotten seriously ill. So that's an issue that every employer has to be sensitive to. So how about some pragmatic, relevant, real-world things to be concerned about and follow up on? One of the most important is your business, your employer should have employment practices liability insurance. And it's definitely needed if you have 15 or more employees, but you may get sued on other employee claims, even if you have less than 15 employees. But you want to make sure that insurance is in place. It'll provide for cost of defense, and depending on how much insurance you take out, it'll provide a payment of claims that might be made by employees. And it's not that expensive. So you should be reaching out to your insurance brokers and make sure that you have that insurance in place. Sometimes it's an add-on with other kinds of insurance, so you may already have it. But if you don't, right during this presentation, you should be calling your insurance broker and make sure you have EPLI insurance in place. We're going to be talking about the expansion of whistleblower retaliation claims. There are a lot of new policies and a lot of things going on now where the traditional work environment has changed maybe forever. And as a result, you have more and more employees who are complaining about the company not following laws, rules, and regulations. And if an employee complains, and it can be oral, that doesn't have to be in writing, and then suffers some kind of adverse employment action for some other reason, or because they complained, the employers can get sued for a whistleblower violation. In Florida, it's Florida statute 448.01, 448.01, and a few section numbers thereafter. But you're going to see more and more whistleblower claims. Plus, you're going to see more and more employees filing False Claims Act claims, also known as key TAM claims. And it's a lawsuit brought by a private citizen. It's almost like a derivative action where a citizen files on behalf of the government, really, because some company has ripped off the government. They've charged the government way too much money, or they've taken money from the government, Medicare fraud, or overcharging, failing to pay taxes, etc., state and federal. And more and more employees are going to be hiring lawyers to file these claims. The employees can prosecute the claim themselves, and it's filed under seal, secretly. The government has 60 days to decide whether to take it on itself, in which case you sit back and you watch the government, prosecute. Or if the government doesn't, you continue the case with your lawyer. An employee does. And with all the confusion going on about which laws apply and what's changed and what the expectations and requirements are, you're going to see a growth of these False Claims Act claims. Employees can recover, 20 to 30%, and the attorneys can get a large percentage of contingency fee. So there's a great incentive for these kinds of claims to be brought. FLSA overtime cases, we've always spoken about that area and always will. You always need to know who's exempt, who's not exempt. With all the changes in the workplace environment, now's an important time to update your FLSA audit. Who's exempt, who's not exempt? What are the salary limits? The duties have changed. Someone was supervising before, well, now they're not doing so much supervision. So someone was making independent decisions based on their own judgment. Maybe they're not doing that anymore. There are issues before about docking. You can dock for a whole day, but someone's away, but you shouldn't be docking for partial days. So there's going to be pressure on employers to want to dock exempt employees if they don't think they're really working as much as they should be working, especially if it's teleworking. And if they dock, they may be exposed to those kinds of claims. Plus, with all of the teleworking, it's become so hard to keep track of hours of employees. Everybody isn't in front of a computer and can hit, start and finish, I for in and O for out, and keeping track of the lunch breaks, and are they working during lunch, not working during lunch? Did they start early, not start early? Did they forget to punch in, forget to punch out? Are they eating during lunch? Is their lunch being interrupted? There's so many issues that are involved that as more and more people suffer some, employment action, they're going to be going to a lawyer, and the lawyer is going to be asking about, whether they're exempt or not, and how the time was. How did the employer keep track of time? The statute says it's the employer's obligation. So you have to do whatever you can to keep accurate time. Have the employees, fill in whatever has to be filled in, explain reasons why they did or didn't follow policy, have policies in place on timekeeping. If employees violate policies, they can be disciplined and even fired. But there's an anti-retaliation provision in the FLSA. If someone asks for overtime or makes a claim for overtime, and sometimes phrases it and doesn't even use the overtime word and says, I think I've been shorted on my time. And later that becomes an overtime claim when a lawyer gets his or her hands on it. So you have to be careful not to retaliate and take adverse action against an employee who's claiming that they weren't paid for all their time. So the challenge, I think, has gotten more difficult. And remember, the complaint can be oral. It doesn't have to be in writing. And if it turns out that employees were exempt, but then with COVID and teleworking, they weren't exempt anymore. But then later, God willing, when we go back to a sense of normalcy, they become exempt again. You may want to document, a change of their job description or otherwise, or memo showing that they went back to taking on the kinds of duties that allowed them to be exempt. Remember, in COVID and emergency circumstances, employees can't, if they volunteer and do the same kind of work that they normally do, they have to get paid. So don't fall into a trap where employees volunteer time and then later make a claim for overtime. Remember about meal breaks. It's hard to follow, but a good rule of thumb is 30 minutes of uninterrupted time. I can't tell you how many cases I get where the employer had a policy of every employee taking at least 30 minutes for lunch, and sometimes didn't require them to clock out and clock back in to have a real record, but at the end of the day or end of the week, just cut 30 minutes from everyone's time for the week for each day, because that was the policy and everyone supposedly took lunch that day. The Department of Labor investigates that issue, and lawyers file suit when they see that, because it's not possible that all the employees took lunch from 12 to 12:30, exactly 30 minutes every day. And the issue of whether it was interrupted or not comes into play. If someone's minimum wage and you require them in the pandemic to buy their own materials or supplies or whatever, if they're paying it out of their own pocket, then they actually aren't being paid minimum wage. So that's a potential exposure. If you're requiring employees to line up for temperature checks or putting on protective gear, if that is the kind of thing that's required, that's actually considered workable time. You have to pay for that. And remember, there are some exempt employees who, because of the COVID and teleworking, you start asking them to start doing some other things. Well, it may be that their primary job is no longer exempt, so you got to be careful about that. One tip that I have shared with you in the past is you can have a policy that says no one can work overtime unless they get prior written permission, but if they work overtime without permission, you must pay them the overtime. You can discipline them and say, "Don't, you violated the policy. If you do it again, you're subject to being terminated without further notice." But you have to make sure you pay for that time. The other issue, other kinds of employment claims we know about in the current situation, dealing with discrimination, harassment, hostile working environment, and retaliation. All the decisions being made as to who gets furloughed, who gets terminated, whose job changes. People are more sensitive to filing a discrimination claim. Why is it that only the black employees were furloughed and not, why were the women furloughed? Why were the pregnant women furloughed and not brought back? Why were the older workers furloughed and not brought back? So it opens up an employer to all kinds of discrimination kind of claims. The FMLA and ADA still apply. So under the statutes, the new statutes or the regular FMLA, if someone has a serious health condition and the employer, becomes aware, the employer has an affirmative obligation to provide the full FMLA paperwork, assuming that the employer is obligated to comply with FMLA. And the employer, remember, can't just sit back and wait to see whether the employee steps forward or not. Similarly, under the American with Disabilities Act, whether you have an employee with, is more prone to be susceptible to COVID-related problems, who's impaired or perceived to be impaired, if the employee knows or has reason to know that the employee may need some reasonable accommodation, the employer has an obligation to engage in the interactive process. You can't just sit back and keep your head in the sand and wait to see whether an employee steps forward or not. You should reach out to employees and see whether they have a disability, claiming they have a disability or need a reasonable accommodation. You have to be a little careful, because if the employee doesn't have a disability and isn't asking for any reasonable accommodation, if you perceive or treat the employee as if they do, that's actually that could expose the employer to liability for regarding the employee as having a disability. So you just have to be careful as to what you do and how you do it. But once you know or have reason to know, you do have an affirmative obligation to engage in the interactive process. Mistakes to avoid in implementing sick leave policies, especially now. Don't be inflexible. Don't be harsh. Try to be a little flexible and tolerant, because if you're nasty to your employees, and they'll get pissed off and they'll find a lawyer and they'll find a way to make a claim. So try to be as flexible as possible. Apply policies consistently. Don't be inconsistent. Don't apply them for, don't give leave to younger workers, but not older workers, it's whatever the protected categories are. And don't ignore all the leave laws. Don't, pretend that these are special circumstances and we don't have to follow the leave laws that are out on the books, or CDC, guidelines and regulations as to who's an indispensable worker and who's allowed to have time off, et cetera. Terminations is a very, very sensitive area for obvious reason. You want to plan terminations. If you're going to have a reduction in force, or you're going to be letting certain people go, you have to give some thought to it. You can't just be arbitrary about it, because it could open the company up to a claim. If you come up with a plan, but the consequence of the plan is that you sort of had a neutral plan. You weren't discriminating against anybody, but the impact was that it affected all the women, or affected blacks, or affected, a religious group here or there. That could expose the company. The WARN Act applies if you have 100 workers. You have to give 60 days notice of the fact that you're letting them go or closing a plant. You have to give certain demographic information as to the backgrounds and ages of the particular employees who are affected by a reduction in force or closure. You want to be careful to deal with benefits upon someone being terminated. A lot of employers make a mistake where they just say, well, we're going to terminate your employment, but I'll tell you what we'll do. We'll give you 3 months, severance, and we'll keep you on our company's group health insurance policy for 3 months. Well, the insurer may find out that that person was not an active employee, and your policy says it only applies to active employees. So there may not be coverage, and then all of a sudden the employer may become obligated to an employee who is denied coverage. If you're going to furlough employees, as I'm sure many of you have been involved in doing, do it, correctly and carefully. I've come across one instance where, the employer said, well, we're going to furlough you and we'll get back to you, talk to you about, coming back, and then never called, asked for the keys, had them take their personal stuff home, et cetera, et cetera. And, there's an issue that came up where they terminated or not, or just furloughed. So you want to document what you're doing and stay on top of it. You also want to avoid letting people go and say, well, I'm letting you go because of COVID. That is it's ambiguous. Are you letting them go because you think they have COVID, or are you letting them go because the impact that COVID has had on the business, and therefore you need a reduction in force? So be very careful about how you document what you say. On the return, after you furlough people, again, you have to be careful as to who you bring back. If you furlough, 50 employees across the board, but you only bring back certain categories of employees, you may be opening yourself up to a claim. There's also something called what I call the fog of war. A lot of employers think that generally, even before COVID, that if you do a reduction in force and you let go, you're going to let go of 25 employees. Some employers think that this is a beautiful opportunity, a perfect opportunity to let go of all the old workers who you couldn't fire before because you didn't want to get sued for age discrimination. So when it's time to decide to do a reduction in force, it turns out all the old workers get let go. Or because of COVID, there's going to be a reduction. Well, now's the time to discriminate against, X, Y, and Z employee. And there's some racial animus, religious animus. Someone's got a disability and can't and is too much, has too big of a accommodation request of the employer, et cetera. So a lot of employers think they can get away with letting people go for a discriminatory reason, just because COVID's an excuse. Well, COVID's not a guarantee that you can get away with that. So you got to be very careful as to who you let go. On unemployment, a lot of unemployment claims, and I think I'm one of those persons who think that don't be penny wise and pound foolish. What happens is if you let an employee go and the employee files for unemployment, there are times where you let the employee go because they were a horrible employee. They were cheating. They were, stealing hours. They were not performing, not responsive, whatever the reasons are, and you let them go. And then they apply for, and that's, they're not very happy about being fired. And then they apply for unemployment, and then the employer opposes unemployment and tries to take the position that there was statutory wrongful misconduct. And in that instance, maybe you got to be careful what you ask for, because now, if the employer wins that hearing and the unemployment is denied, now you have a worker who was really pissed off they got fired, but now, adding insult to injury, now you oppose their unemployment claim. And now they go to a lawyer and now they want to sue because they're really upset about what happened. So you got to try to evaluate and judge whether, fighting that unemployment claim is worth it when, if you have to pay unemployment, if you found that you're obligated to pay unemployment, it's a relatively small increase in cost to you. But if you piss off an employee that badly, you may open yourself up to an overtime claim or some other kind of claim that the employee otherwise might not ever make. And sometimes an employee doesn't know what kind of claim they have, but they go to a lawyer because they just got screwed. They feel they just got screwed. And the lawyer, it goes down a checklist of potential claims they could bring. So you want to be very careful. You don't want to act out of spite. There are a lot of employers who sort of don't like those employees they let go, and they want to deny them unemployment, and that could come back to bite you in the ass. We spoke about a whistleblower before, and you've got to be careful because any adverse action you take against an employee could be a basis for a whistleblower claim. If they make a claim that's protected for discrimination, overtime, workers' comp, or if under the general whistleblower statute, they object to the company violating a law, rule, or regulation, and then because of it, or contemporaneous around the same time, some adverse action is taken, then they have a whistleblower claim. If they got fired and they can't get another job for 2 years, the employer may be on the hook for 2 years worth of salary, plus benefits, plus attorney's fees. There are a lot of employees complaining about a lot of things now. Employees sometimes get fired because they complain. But sometimes if the employee is talking to other employees about, bad conditions at work, if that employee is fired, sometimes they're deemed to be someone who's trying to organize, and the firing could be in violation of the anti-retaliation provisions of the National Labor Relations Act, because sometimes workers will organize and form a union because of gripes they have about the working conditions. And if someone complains about working conditions and gets fired, it can stop workers from being able to organize. So you got to be careful in, being sure not to fire someone, just because they're expressing negative opinions about work conditions, et cetera. The False Claims Act claims I mentioned earlier. It's a historical fact that the statute was enacted during the Civil War because unscrupulous contractors were cheating the government on the war contracts, and that's where it started, and it stayed with us all these years. It's important to have a couple of agreements in place that I strongly recommend for employers. Consider having all the employees sign a mandatory arbitration agreement. Instead of getting sued and having a case go to court, sometimes and have a case tried in front of a jury if we ever get jury trials back again anytime soon. Some employee claims are believed to be more valuable by employees and their lawyers if they're in court, and open to a jury trial. And very often, employment law lawyers representing plaintiffs don't want to have to go through mediation because very often mediators are professionals. They've seen these claims before. They're not, the claims don't tug on their heartstrings, and they're more apt to be pro employer as opposed to a jury that might be a jury of an employee's peers and be more susceptible to wanting to rule for the employee. Things have changed a little bit now because you can't push a claim through the court system. It's so tied up. Arbitration may be the way to go. So sometimes employees actually don't mind it as much as they used to, but it's more helpful for an employer to have mandatory arbitration agreements in general. Also, restrictive covenant agreements, non-compete, non-solicitation, non-hire, non-disclosure of confidential information, etc. You'd be amazed at what happens when you have employees who are doing really well. They want a raise. You don't give them a raise. They leave. They go to a competitor, and they take clients and other employees with them, and they could really damage your business. They could open up and compete against you. So if you want to stay protected, consider restrictive covenant agreements. And if you're going to have them, make sure they apply across the board. And you can't have your janitor sign one because there's no legitimate business interest to protect that a court will enforce. But if it's a higher level employee handling more sensitive information of a confidential nature, where there's a lot of training involved, where if that employee left, it would hurt the company. And if the employee left and helped the competitor, it would unfairly help the competitor, in very general terms. So you may want to have your business or the employer you work for consider restrictive covenant agreements. But if you only have it with half the employees in that category and not the other half, it makes the judge wonder how important was it to protect what you're trying to protect if you only had half the people sign one. So you want uniform execution of it, and it doesn't have to be at the beginning of employment. It could be sometime during employment. Another issue has to do with re-onboarding, bringing employees back. If you're going to bring employees back, you want to do it carefully and correctly. If they were terminated, you actually want to be sure that you're re-onboarding the employee. Have them re-enroll in the insurance benefit plans and re-sign the employee handbooks and arbitration agreements and restrictive covenant agreements, etc., as if they were a brand new employee. Family Medical Leave Act, I spoke about earlier, and also ADA. You want to stay on top of those areas. You have to be a little careful in no good deed will go unpunished. Sometimes when you think that you're better off firing the pregnant women and the older employees because they might be more prone to be exposed at work, and you think you're doing them a favor, you might be opening yourself up to a discrimination claim. We're also at an area, especially now with the election results as they are, the federal government may be getting more involved in what kind of program needs to be put into place in the entire country. And maybe there's mandatory testing, maybe there's certain preconditions before someone's allowed to come back to work, contact tracing, et cetera. So it opens up privacy issues and other kinds of claims that we're not used to yet in our country. In Asia, where they've had a number of epidemics, I guess, and some pandemics in the past, they've been much more strict and much more responsive. Taiwan, South Korea, and I guess China to an extent also. Vietnam and some other countries are very, very strict in what they've done. So, these pictures were taken back in like May. I mean, as soon as the pandemic hit, you were in quarantine, you you stayed in your house, you had to get tested, there's contact tracing. If you were positive, you couldn't stay with family or go to work or go in public places. You had to be certified. You got a QR code on your phone or on a tag around your neck. You wouldn't be allowed to go into certain places or buildings or malls, or et cetera. Your temperature was taken. So surely there are going to be a lot of these procedures put into place, and it's going to represent some challenges in the employment area. Invasion of privacy questions, potential HIPAA violations, etc. Contract litigation is continuing. We're seeing more and more of these cases where, because of the pandemic, parties are not performing, tenants are not paying rent, mortgagors are not paying their mortgages. They're raising various defenses. So there are all kinds of legal issues raised specifically because of the pandemic. Is there such a thing as contractual immunity? Can employers have employees sign an agreement that says, in coming back, you agree not to sue the employer ever for anything, but you're assuming the risk? Those agreements are questionable. A lot of employers like to have them because it's a way to see which employees are worried about coming back or not, and they also sometimes it'll dissuade employees from filing a claim if they've signed such an agreement. But there aren't a lot of court cases yet as to whether those kinds of agreements would stop an employee from being able to sue. The general feeling is that if you have an obligation to have a safe working environment, you can't have the employee sign a waiver. That would be against public policy, because in that case, every employer could do it, and no work environment would be safe. So in the current environment, with the vaccine far away, with difficulties with reopening back and forth, the flu season coming, this may be the worst time that we're dealing with the virus over all these months. For a while, we won't know how long it's going to be. Employers have to stay very prepared and observant to make sure they're doing the right thing in their workplaces, implement technology that's necessary, create new policies and procedures, consult with legal counsel, consult paymaster, monitor the new guidelines that keep changing as to what can be open, what can't be open, and it's necessary to follow those guidelines. And now's the time you have to strike a balance still between personal health and life and safety issues and business survival. So it's a very difficult challenge. So that's the end of my presentation. I'm happy to respond to questions that you all may have. Thank you for being patient. I think under the circumstances, it would have been a little difficult to try to take questions as I was going, especially with people and what I'm trying to do. So I couldn't be as much fun and personable as I usually am, but maybe you'll ask me some questions that'll get me going a little bit. So thank you for listening, and I'll put the presentation on my website tomorrow. As I've told you in the past, you can all call me and raise some questions and issues with me. I don't start my meter as soon as I pick up the phone. I'm happy to talk to you and be helpful. I love the area, and I've been fortunate over the years where some of these presentations lead to relationships that I start, in employment areas. So I'm happy about that. But otherwise, I'm happy to help any client and customer of Paymaster, and I cherish the relationship. So I'm happy to try to answer any questions you have. Just because I finished, just because there might be 20 minutes left, it doesn't mean we have to ask 20 minutes of questions. So don't kill yourself. But maybe if we finish early, you'll like my presentation even more. So I'm happy to respond.